No accommodation. You redistribute the rank amongst yourself if you don't desire. Yes, proceed.
Please. Very briefly, I just recap. I was concluding my arguments on the interpretation of
Already concluding.
Yes, on Article 200, my lords. On Article 200. Just very briefly, I'll recap that. And then go on to the next point. Well, I had respectfully submitted before your lordship.
So you stopped at 3 options.
Yes. So I said that there are 3 clear options in the main part which talk about shall declare, and each has a finality or a consequence attached to it. Withhold of assent means the bill falls. Assent means it becomes a legislation, and reservation for the president means it goes for the president for his assent. The proviso is more in the nature of a preliminary option or a consultative process.
You already argued.
Very sensitive to it. The words at the end of it, which are shall not withhold assent, have been sought to be argued to mean that it is an adjunct to withholding assent, which it is not.
They are not yet started the argument.
No, my lords, even in the ultimately, my lords, somewhere or the other, what was argued in the Tamil Nadu matter comes in. And that is why I am just saying this. That one of the arguments forwarded was that since the last line of the proviso says, shall not withhold assent, it necessarily means that the proviso is an adjunct to withholding shall declare and withhold assent. And as I respectfully submitted that neither the textual context indicates it. The judgments clearly say shall fall. And unless can surely, even by the ordinary dictionary meaning as used in those judgments, never be meant to mean that if you withhold assent, it must be sent to the assembly. Unless can never mean that. Unless is a consequence that it shall fall through, unless of course it is sent, where then it's deliberated again. That was as far as 200 is concerned. My next argument, my lords, for your lordship's kind consideration and the historical significance I had shown, your lordship said there's no need to go into it because there are judgments on the point. Returning was a distinct option given earlier from the 1919 Act right through. Return was a distinct option. 3 in the main part and proviso. There it was in the main part in the 1919 Act, then it evolved and became a proviso. But it was always a distinct option given there in my lords. The second point for your lordship's kind consideration, my lords, is that does discretion exist in Article 200 and 201 or not? My lords, your lordship's repeated judgments on the points have said that this decision will be made irrespective of any advice from the Council of Ministers, and the exercise of this discretion, the governor must discharge his duties to the best of his judgment, is what Shamsher Singh says, and followed then in Navam Rebia and B.K. Pavitra. It was again sought to be argued that discretion is completely bound and there is no independent discretion by the aid and advice. That was specifically rejected, and this is what was said. Now, my lords, please have Article 167 of the Constitution for a minute.
One
167.
Yes.
It says, it shall be the duty of the chief minister of each state, and please have B, to furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for. The parameteria provision for the president, my lords, is Article 78. The reason I'm citing this, my lords, is that even with regard to Article 167, which in the draft constitution was Article 147, it was sought to be argued that what is the need for information to be given to the governor? For a proposed legislation, why does governor need information at all from the ministry? Why is the chief minister or the prime minister? The words in 78 are prime minister. Why is the prime minister or the chief minister duty bound to give information to the governor? Because after all, he just has to give his assent. And Dr. Ambedkar, my lords, there specifically said that in fact the governor's duty, and as part of his duty, he must get this information because it is his duty to advise, to warn, to suggest alternatives, to suggest reconsideration is part of his duty. And he has to be given that information, because if you do not give this information, what is the governor there for? That's what Dr. Ambedkar said. Because he ultimately is not a representative of a political party, but represents the people of the state. As the president, as the highest constitutional authority in the country, represents the people. And Dr. Ambedkar went on to say that otherwise he would be an absolutely unnecessary functionary, no good at all. And then said he's not a representative of the party, he's the representative of the people.
It is a vital link between the state government and the central government.
Very grateful, very grateful. And my lords, why I'm citing this example is that the reason information on proposed legislations, there are memorandums in existence where information, when a bill goes to the president or the governor, memorandums on information is asked from ministries on center state implications, on repugnancy, on issues of constitutional concerns. And after this information is exchanged, an independent judgment, an application of mind takes place, and that is why the constitution benches say, irrespective of the aid and advice of the Council of Ministers. That's the point I'm seeking to make for your lordship's kind consideration. In fact, my lords, in B.K. Pavitra's case,
according to you, even if second time also the Council of Ministers reiterates the bill, still the governor has a discretion not to give access to it.
no, my lords, if the assembly reiterates a legislation, the constitution is very clear. Then after that, he can either give an assent or send it to the president. He shall not withhold assent. I'm not saying that he can still withhold assent, because that would be in the teeth of what the constitution says. All that I'm saying is that the exercise of discretion by the president or the governor, as far as this issue is concerned, involves an independent exercise of opinion and judgment. As far as shall withhold assent is concerned, as far as shall assent is concerned, as far as shall declare that it is being reserved to be sent to the president. It is his independent exercise is all that I'm saying. I'm not for a minute suggesting, my lords, that if he sends it for reconsideration as a fourth option, as a part of a consultative process, because ultimately, my lords, the governor under 168 is also part of the legislature. And your lordship has said that he is part of the legislative component, is what your lordship said in next. So as part of that legislative procedure and component, as part of it, if he sends it back with suggestions, with considerations, as I respectfully submitted on the last date, there could be cases where he's willing to give assent because he feels some things need to be tweaked. It could be cases he feels before it's sent to the president, certain things need to be addressed. So that is part of that consultative process that he sends it back to. But yes, of course, after that, if the legislature in its wisdom reiterates it in whatever form, his right to withhold goes. But his right to withhold in the main part is an independent exercise of his discretion. And the consequence of it is contained in the constitutional bench judgments to say that it shall fall. That is what I was saying. The second argument, the second argument that I'm making for your lordship's kind consideration is this independent exercise of judgment and discretion. As is borne out by these judgments, this is his judgment which matters. In fact, my lords, in B.K. Pavitra's case, an issue arose that when the governor refers a matter for consideration of the president, should there be grounds on which he can refer it? My lords, the this court answered it by saying that the framers of the Constitution deliberately and carefully eschewed defining the circumstances. You can't define circumstances under which a governor refers to the president. There are issues and issues of constitutional concerns, complexities which will arise. And you can't put them in a straitjacket formula. That will have to be left to the wisdom of the governor. And that's for him to define and decide. And they said that the very nature of conferment of power cannot be confined to specific categories were the words used by the Supreme Court. That's the very nature of conferment of powers that is granted there. So you can't say this will be in the straitjacket formula, only then we'll do it. That has to be left to his right discretion, which is vested. Now, my lords, as far as the issue of discretion is concerned, my lords, as my lords has also pointed out, under Article 163, one is by and under the Constitution. Then there is 163(2). And your lordships in any number of judgments have said that it could be explicit or it could be implicit, depending on the facts of a case. For instance, my lords, under Article 174, normally, my lords, as held in Shivraj Chauhan's case and other judgments, a house is summoned or a session is summoned on the aid and advice of the ministers. Yet there can be a situation where the governor is of the view that the council of ministers or the government has lost the confidence of the house. And in that case, he's not going to wait. The council of ministers which has lost the confidence of the house is going to suggest there should be a floor test. That's an independent view in discretion that he exercises under 174. To have a floor test or a summoning the house to prove your majority on the floor of the house. All that I'm saying is there are any number of instances where, my lords, the discretion has been vested in the governor or the president, whether explicitly or implicitly. My next submission, my lords, for your lordship's kind consideration is on the issue of timelines. My lords, in Purushothaman Nambudri, the judgment which the learned solicitor had also cited, it has been clearly held.
Which judgment?
My lords, Purushothaman Nambudri, just get the citation.
Purushothaman.
Yes.
Yes.
My lords, that was 1961 SCC Online Supreme Court 361, Volume 3 of the compilation, the judgment of a constitution bench. The issue was also, my lords, does a bill lapse with the assembly, with the life of an assembly? They said no. Even if the life of an assembly comes to an end, for the reason that there is no timeline provided.
That the learned solicitor has already...
Yes, so I said, so my lord, the learned solicitor pointed out there is no timeline. Where, in fact, my lord, the timeline requires to be provided. The timeline in the Constitution is categorically provided therein.
That's not also learned solicitor.
Yes. So, for instance, under 201, there is a time period given.
You may argue what is not argued.
Very well, very well, very well, my lords. So, my lords, as far as timelines are concerned, my lords, our respectful submission for your lordship's kind consideration is that, again, as far as those memorandums, etc., are concerned, where information from ministries is asked for, memorandums are considered, etc., it is impossible to say that within this timeline the governor or the president must decide, because there will be all kinds of procedural and substantial complexities. There will be issues, there will be a back and forth.
We already argued.
Yes. Next point for your
at length.
At length. Next point for your lordship's kind consideration. My lords, your lordships have time and again on the issue of judicial review said there is, and on this I'll devote some time, my lords, that
scope of judicial review.
Scope of judicial review.
By considering the discretion exercised by the governor.
That's right. That's right. Including the issue, my lords, which my lords flagged to me, that suppose there's a constitutional vacuum. Your lordships are kind enough to point that's a concern. I'll deal with that. My lords, there is no doubt that in any number of judgments, your lordships have held that the power of judicial review is implicit in a written constitution unless expressly excluded. There's no doubt about it. It is written in for every power vested under every provision. The power of judicial review is there. But your lordships have also consciously, my lords, in AK call downwards in judgments have held that as a facet of judicial review is justiciability. And there is a difference between judicial review and justiciability of a particular action. And your lordships have also held.
That is also argued by the learned.
Malas, I need to argue something.
No, you can
I'm just developing on that.
Please don't say the argument which are already.
I just develop and just leave it.
Otherwise, Mr. Jetmani will never get a chance.
Yes, no, Malas,
If all of you are going to again argue what has been argued by the solicitor.
No, my lords, you won't. The reason I'm saying so is, my lords, the reason I'm saying so is that the action of judicial review is always tested on the touchstone of the Constitution. Now, as far as justiciable, manageable standards are concerned, my lord, your lordship says that where there exists none, the action is not susceptible to judicial process. That's all that I'm saying in these cases. Now, why I'm...
Please repeat your argument.
My lord, I am saying that where there are no justiciable standards on a particular action,
Where there are no justiciable standards.
for a certain action,
No justiciable and
manageable, justiciable, judicially manageable standards is what AK call refers to.
Manageable.
Judicially manageable standards. Where there are no judicially manageable standards to judge an action, it will not be susceptible to judicial process. So within judicial review, although it's inbuilt into the Constitution under every provision, there will be actions which are non-justiciable. Because, as the Supreme Court says, there are no judicially manageable standards for them. So no one is saying that the power of judicial review is not implicit. The power of judicial review is implicit in every provision. But there will be certain powers, there will be certain discretions vested, which do not have justiciability aligned to them, because they're incapable of being adjudicated upon. And I'll tell you, lordships, I'll give you lordships examples as far as this exercise of power are concerned. Any judicially manageable standard requires an objective, ascertainable criteria. Now, effectively, my lords, in exercise of all these decisions, there is a certain operational and substantial complexity. There are considerations of stakeholders. There are interstate relations. There are consultations with ministries. There are public interests which are involved. There are constitutional conventions and not just basic fixed rules involved. And that is why I say, my lords, this cannot be compared to the exercise of power under Article 356, and I'll just come to that. This is sui generis in itself as far as the exercise of power by the governor and the president is concerned. Under 356, my lords, for instance, when your lordships in Bomai and other judgments dealt with, there is a failure of a constitutional machinery. There is either a report from the governor or otherwise, and a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. That the court felt in the given circumstances was something subject to judicial review, and of course, if arbitrariness or malefides are shown therein. All that I'm saying is this form of judgment and exercise of opinion of the governor and president by its very nature is not justiciable. Now, the question that your lordship is supposed to be on the last date.
Under section 356.
Please.
The discretion exercised by the governor under 356.
Yes.
Is justiciable.
Yes.
Then why not the discretion?
Yes, my lords, that's exactly what I'm answering. That there are contours where it is justiciable. Breakdown of machinery, failure, report of a governor, the government cannot carry on any longer. All that I said was there are a lot of substantial and constitutional complexities when a decision is made under 200 and 201. Stakeholders, interstate relations, constitutional concerns, constitutional conventions, and then a judgment in his wisdom is made on these parts. And that is why your lordship said that even an assent given by the president is non-justiciable. Your lordships categorically held that neither the legality or the deliberation as far as the assent by the president is concerned is justiciable. In Kaiser Hind and other judgments, your lordships have categorically held that and in Hext, I think, that the assent given by the president is non-justiciable. And why did your lordship say that the assent given by the president is non-justiciable? I'm trying to draw sustenance to that argument by saying because there are no legally manageable standards to determine that. That's an issue which is decided in the wisdom by relevant material which is before them. And the argument cannot be, my lords, the argument cannot be that what happens if a governor sits on a bill indefinitely? For the simple reason, my lords, that your lordships have time and again said that the court will not likely presume abuse or misuse. And then what your lordship said that the court,
when the power is exercised by the high functionary,
at the highest constitutional functionary of the country or of the state. And then the words used by your lordships were that the court would, as it should, in Bomai. The words used were the court would, as it should, tread warily, making allowance for the fact that the president and the Union Council of Ministers are the best judges of the situation, that they alone are in a possession of information and material.
President and Council of the Ministers.
And because that there it was of the advice on dismissal. And that. The issue here is, they said the words used were that the Constitution has trusted their judgment in the matter. Why I am emphasizing this, my lords, is that the starting point can't be that there will be a misuse. If there is a misuse, my lords, the argument is not that the court is powerless. The question is it something, very often, my lords, your lordships have said in this and many other matters, your lordships have said on many issues, Parliament shall rethink. Then your lordships have said that at the cost, in fact, the words used in one of the judgments was, my lords, at the cost of repetition, we observe that it is for the Parliament to take a call on that. There are issues which can only be decided by Parliament or in the political sphere. So if a situation arises of an egregious conduct by the governor or any other constitutional authority, then Parliament has to take care of it. The answer can't be today to lay down a timeline and then say this timeline will be judicially reviewable. The answer can't be that. And my lord, the Chief Justice self had pointed out on the last date, I'm not even going the route of those Telangana and other judgments. Your lordship said with regard to the speaker. Your lordship said tribunal, and not only that, my lord, your lordship also said
there is no immunity available to the speaker when he acts as a tribunal.
Not only that, my lord, the other thing which weighed with your lordships was that the life of an assembly is 5 years, and why should anyone who is otherwise incurred the wrath of defection should continue as a member of the House? And that was one of the considerations.
On the same analogy, when the houses, both the houses of the legislature, on 2 occasions, have given their approval to a particular bill, why should the president sit on the governor committee to sit on it for an indefinite period of time?
I am not for a minute suggesting, my lord, that he should sit on it for an indefinite period of time. I am only arguing.
We appreciate that we may not fix our timetable, 15 days, 30 days, 30, 45 days. But if somebody sits on bail from 20 to 2020 to 2025, should the court be still powerless?
Maharaj, that is why I started on the presumption that...
we appreciate your submission that for considering a validity of a provision, the abuse of process or the abuse of powers, when particularly they are exercised by the highest constitutional functionary, should not be strictly assumed by the court. We appreciate that submission. That is also the submission made by the learned solicitor.
And also, my lord, your lordship's judgment which say that the presumption is raised that the power will not be misused.
Yes, we are aware about that line of judgment.
Absolutely. So all that I'm saying is, my lords, if a situation like that arises, I'm not for a minute suggesting that an egregious conduct on the part of the governor, then the question is, who takes care of it? My respectful submission is, this is an area which is best left to Parliament to decide on. Because your lordships and many judgments have said, that it is time for Parliament to rethink. Your lordships have also said that it is for Parliament to take a call on that. Absolutely. In fact, I know those are your lordships, the lines. However, at the cost of reputation, we observe that it is for the Parliament to take a call on that. So all that I am saying is, my lords, that ultimately when your lordships interpret a provision also, including the 5 judges and Manoj Narula, your lordship said that ultimately some interpretation has to be based on some resting pillar or strength on the basis of some words in the Constitution. Your lordships have repeatedly said that when an interpretation is given, there has to be a resting pillar. There has to be some strength to it, to words in the Constitution. You can't rewrite the Constitution. Those are your lordship's words, is all that I'm saying. So an interpretation which completely rewrites or introducing timelines which are not conceived, which are not there, because it is presumed that if it is misused, this should be the timeline. That's why I said, my lords, in all humility, the starting point of this debate can't be that there could be a vacuum, we apprehend someone could misuse. It may have happened in a particular case. I'm not on any particular case, I'm on the principle. It can't be that the presumption will be that there will be a misuse, and thus we must, as a constitutional court, set it right by setting down timelines. That's all that I'm saying. Because after all, your lordships have said that it will not be lightly presumed that the power will be abused. And we'll tread very warily and carefully as far as these issues are concerned. That's all that I'm seeking to say.
That's what the solicitor also said.
Yes. Now, my lords, the next point for your lordships' kind consideration is,
So all the same arguments why 5 lawyers would not make it strong.
No, my lords, I'm just completing. I'm just completing in 10. Give me 10 minutes and I'll complete it.
We are not. We are only saying that it doesn't mean that the same argument need to be repeated by everyone.
No, my lords, we are just in 10 minutes and we are complete.
I appreciate it if somebody comes up with a new point.
Yes. My lords, as far as my lords, as far as deemed assent is concerned, in any matter as was given therein, my lords, under Article 142, my respectful submission is only one, my lords, that this is completely impermissible judicial reallocation of constitutional functions from a high plenary constitutional authority, that is the president or the governor, to the Supreme Court. It's completely impermissible that such judicial reallocation under the constitutional functions can take place. It is impermissible. As far, my lords, as the question of seeking the opinion of the Supreme Court is concerned before any assent being given, my respectful submission is, my lords, in repeated judgments, your lordships have held that judgment, opinion of the president on assent is non-justiciable. He weighs well within his rights to take a decision, and it's not an idle formality when he takes this decision. It's in a discretion vested in him and not as an idle formality that he takes this decision. Whether it's under 200, 201 or Article 254 or any other article. And surely the opinion of the Supreme Court, when he wants it, he seeks that opinion. And then it's for your lordships to answer or not answer it. I'm very grateful, my lords. I won't take any more of your lordships' time.
Thank you.
I'm very, very grateful for your lordships' kind consideration.
Lordship from Maharashtra, Mr. Harish Sarve is appearing online. So Lordship may.
That you have to decide.
Yes, sir.
We have about the sequence. We have a sequence.
As per the sequence, Mr. Sarve is to follow. Admit Karno.
Made, please, Madam.
Yes, Mr. Sarve.
But I've written out a skeletal note so that we can go quickly. I believe starts at page 630.
The submission is that.
Yes, but this is more, it's not a detailed written submission. These are more like headline points and some arguments. And I will quickly, only for giving the background of what the points which I would endeavor to underscore, Malad. I may have to just state certain points which your Lordship may have heard, so your Lordship can just give me that accommodation. I will not argue those points. In the first 5 paragraphs, first 4 paragraphs is what I call the background to the interpretation. Article 200 is a part of our legislative procedure. And that's noted. My Lord, before your Lordships read this, may I tell my Lord what is the nuance which I propose to place before your Lordships for your consideration? In my respectful submission, my Lord, we have to be careful we don't place the cart before the horse. We are a constitutional construct which resembles a federalism, which is like a federalism. But the word federalism, like all political constructs, may be of various kinds. Your Lordships have heard this over and over again. The important point is, my Lord, how do we define our constitutional federalism? Do we look at our constitution to see how a federation has been created? Or do we interpret the provisions relating to the relationship between the Union of the States with a priori notion that these have to be understood to conform to some theoretical concept of federalism? And I make bold to say, the framers of our constitution have created a system in which the union can refuse a bill passed by an assembly from becoming law. So, my Lord, this, what is uncharitably characterized as a veto, and I'll see why I call it uncharitably characterized. That exists anywhere in the Constitution. Unless we rewrite Article 201.
But according to you, the union can reject a bill passed by both by the houses of the state legislature.
Yes, ma'am. Should it is a matter of high discretion.
We are not.
We always say
We are not,
in rare circumstances.
we are not going into question of should it or should it not.
Exactly.
According to you, the union has the power to do so.
Yes, ma'am. And that is plain from the language of the proviso to 201. So this entire exercise of trying to avoid a veto-like power overlooks that the language of 201 does not admit of any such limitation. Now, if that is the starting point of the debate, and we give up the notion that finding a veto is antithetical or erodes a federalism as envisaged by a constitution, then we come to very different conclusions. There are two articles which have not been addressed are the width of 361 and judicial review. And ultimately, Malad, we all come to they will all lead to the same conclusion. Whether you look at it from the justiciability point of view or you look at it from the functional and the operational point of view of how these articles operate, the conclusion will be the same. And that's what I propose to Malad, put across your Lordship's kind of consideration. If vetoes are not an anathema to the constitutional scheme, then let us start without any preconceived notions, seeing what the language of Article 200 leads to.
According to you, the governor has a veto power under Article 200 to withhold.
Not using words like veto perhaps are an uncharitable characterization. The governor has the power to withhold assent. When
you only argue that if vetoes are not anathema to the Constitution.
Malad, I said what is uncharitably characterized as a veto. Malad, I said what is uncharitably characterized as a veto. But it's a convenient shorthand expression. But I call it, that's why in my vote also I said it's uncharitably characterized as a veto. But veto has certain pejorative consequences which you don't use for high functionaries. But a veto is something you use for personal interest. Nobody here acts in personal interest. Now, to get to where I have, Malad, there are 2 or 3 basic points which we need to keep in mind. And this is our federalism. What defines our federalism? Let's be clear. The Constitution, if you're not as para 1.2, I made this point. We have a marked difference in the scheme in relation to the legislative provisions relating to the union and the role of the president vis-a-vis the union government, as against the legislative provisions relating to the states. So we start from there.
Just for sake of clarification,
Yes.
your argument was that the union has a right to reject a bill passed by the legislature.
Yes.
So whether that power can also be exercised by the union in respect of list 2?
Yes. I'll make it good. I'll make it good.
Even if there is no representative with the central law.
Absolutely, Malad. Under Article 201, there is no such limitation. Malad, we have always started this with certain preconceived notions. There is a separate 254.2 is a different matter.
What happens to the Constitution reserving subjects in list 1 only for the union, subjects in list 2 only for the state legislature, and in the list 3 for concurrent list?
But that is 254.2, Malad, not 201 proviso.
So,
There are separate powers.
while reading 200, we have to ignore 254.
No, Malad, they are independent powers operating in independent circumstances. Some of them have conditions precedent, some of them do not. If we start Malad, stitching up these provisions, we are eroding what the framers
The principle which know is of harmonious construction.
Malad, there is no disharmony. There is absolutely no disharmony. If we start with the premise that any such stymieing of a bill made by the state is antithetical to the constitution. If we start with that premise, then the disharmony starts. If we read the constitution to understand what was the structure the founding fathers had in mind, then the disharmony disappears. So that's why I start by saying we don't start with any preconceived notion. Let's try and find out what the constitution says. And that's why, my lord, I don't propose to cite any judgment. I invite your lordships to read the article.
Yes.
The first is, my lord, let me cut to the chase. If your lordship pick up 201, and my lord, your lordships have been told this repeatedly, and long reasons have been given. I need to only state it. Each word of these provisions was carefully calibrated. Look at 201, where a bill is reserved by a governor for the consideration of the president. The president shall declare that he assents to the bill or that he withholds assent thereto. And provided where the bill is not a money bill, the president may direct the governor to return the bill to the House, or as the case may be, houses of the legislature of the state, and with such message as may be mentioned. And when the bill is returned, the House or Houses shall reconsider within a period of 6 months. And again, if it is passed by the House with or without amendment, please mark the words, it shall be presented again to the president for his consideration. Now, my lord, and your lordship has seen the language of the first proviso to 200. I don't need to go to it right now. I will at some point deal with the language. The words shall not withhold assent therefrom are conspicuous by their absence and cannot be read in. He would be rewriting this proviso. This defines Indian federalism. And my lord, there is nothing shocking about this. High constitutional functionaries in a democracy are in the ultimate analysis.
Dr.
Democracy functions by the good sense of the people.
Dr. Ambedkar in his speech of 3rd of November 1949
Yes.
elaborately expresses about how our federalism works and how it is
Yes.
distinct from the American system.
Correct, man. And that is very important. If your lordship, the speech has been shown. The essence of that speech
And
was
what he says that except the situation of emergency, the states would work within the fields assigned to them, and the union would work within the spheres allotted to them. And only when there is an internal or external emergency, the power shall stand vested with all the powers shall stand vested with the central government, so that the country is united and strong at the times of peace as well as war. That is the words we use.
my lord, that is a completely, may I, my lord, explain? Unfortunately, in some of the cases also, the understanding of 200 and 201 has become competence-centric.
Has become
Legislative competence-centric. Where Dr. Ambedkar also said, it's only in emergency that least 2 powers become available to Parliament. Otherwise, the states have their own sphere and must function on their own. Well, let's start by propositions which cannot be doubted. The state legislatures are what the Constitution calls them, legislatures who have the right to make laws. Having conferred this right to make laws, in our federation, we have 2 parallel models, the union legislature and the state legislature. And my lord, where the Constitution treats the 2 differently, we cannot, Everest said that or remove that difference by reading down or reading up any provisions relating to either of the two organs. Your Lordship has seen the structure, Article 74. Your Lordship has Article 74, for example, and see the difference in language and the difference of how the framers of the Constitution made it. 74, and there are two dimensions to 74, Malad, and since I'm showing the provision, let me make that point also. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, please, your Lordship knows these words, who shall in the exercise of his functions act in accordance with law, with such advice. And here it says, provided the President may require the Council to reconsider such advice, either generally or otherwise, the President shall act in accordance with the advice tendered after such reconsideration. Mark these with the contrast to the proviso to 201. Then, my lord, we have the legislative procedure in part 5, which begins from Article 107, and this culminates in 111. And I don't need to labor the point that the assent is the last step in the legislative procedure. And 111 says, where a bill has been presented by the Houses of Parliament, it shall be presented to the President, and the President shall declare that he assents or that he withholds assent therefrom. There is no, my lord, any further question of referring the bill to anybody or seeking your Lordship's opinion or anything of the sort. Nothing. Provided that the President may, as soon as possible after the presentation of the bill for assent, return the bill if it is not a money bill with a message requesting that they will reconsider the bill or any specified provision, and in particular any desirability of introducing any such amendments as he may recommend. And when a bill is so returned, the Houses shall reconsider the bill accordingly. And if the bill is passed by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Now, this article would have had very different connotations if 74 had not been on the statute book. Because all these functions are to be exercised on the aid and advice of the Cabinet. But the Cabinet cannot alter the bill. If the President, in a dialogue with the Union Cabinet, feels that the bill needs to be corrected, he can request, and the executive government, the Union Cabinet, takes it back to the Parliament. The Parliament may or may not reenact it, but what comes out of Parliament then is the last word. So this is perfectly consistent. The difference here is the President, even while doing so, is acting on the aid and advice of the Union Cabinet, because 74 is untrammeled. And we do not have any discretionary functions of the President, but that's settled. So, my lord, this distinction, the Constitution has marked in para 1.2, the point therefore which I want to make, is marked difference in the scheme in relation to legislative provisions relating to the Union and the role of the President vis-a-vis the Union government. As against the legislative provision, this distinction is a characteristic of federalism in India. So this is how our federalism is defined in our Constitution. The approach, which is based on testing and interpretation of the plain language on the premise that one or the other would be consistent with the principles, amounts to defining Indian federalism in abstract terms and then testing the interpretation of provisions on whether the interpretation furthers or distracts from the abstract notion of federalism. This approach overlooks that the founding fathers carefully craft provisions and define the roles of the two legislative bodies in the provisions of the language, which language does not admit of any ambiguity. Reading down any such language on the premise that the consequence would be incompatible with federalism overlooks that the plain language has to be read to define federalism as understood in the Constitution. So, when we say this is not consistent with federalism, where the language is compelling, you don't stand outside the Constitution to define federalism and then this construction creates disharmony. By itself, there is no disharmony between two provisions. No disharmony. And one of the points which I will address as I go along is the 254(2) versus 200. It is indisputable that the states have their own identity, but not sovereignty. And where the language of the provision of the Constitution is broad and undefined, an interpretation consistent with broad ideas of federalism may be appropriate. But to read down the express language of a provision on the ground that it is incompatible with federalism suffers from the fallacy of circumlocution. Because these provisions define federalism. What is our federalism is what these provisions provide. The second principle, Malad.
Salve,
Yes.
the issue is not so much about what we can, whether we can use the expression veto or withholding, occurring by virtue of Article 201 proviso by the end of it. By the interplay of 200 and 201, eventually when a president, by virtue of Article 201 says the bill shall be presented again to the president and the buck stops there. We are
Yes.
not so